All right, this is Unit 4, and this will be a brief presentation of some of the concepts that you see in Unit 4 and that you've read about. I'm not going to talk about the case law, and I'm not going to talk about the theory. I just want to talk a little on a more practical vein about some of the things that you've read about. And I'm going to limit what I'm talking about to the following: vicarious liability, assumption of the risk, last clear chance, contributory negligence, and comparative negligence. And we'll just take them in that order and just take a minute on each one just to kind of give you some practical thoughts about each matter. Vicarious liability, as you should know at this point if you've done the reading, is the idea that someone who is not negligent nonetheless is held responsible for the negligent acts of another. The classic examples: employer-employee relationship. This happens frequently in car accident cases where an employee is driving on behalf of the employer, drives negligently, causes an accident, injures someone, and the plaintiff, the plaintiff who files a lawsuit against the driver, also typically will sue the employer. And again, the theory is respondeat superior. The superior will respond, right? And this is pretty typical. An example of this might be that a lawyer is driving on behalf of his law firm or her law firm and gets in a car accident, and the law firm can be held responsible for the accident if the lawyer's on the way to court, for instance. So that's a simple example. What this is not, though, and let me make this clear, this is not the same thing as, for instance, a pizza delivery driver who's trying to get there in 30 minutes or less, or whatever, or a sub franchise out here in the Midwest called Jimmy John's, which has what they call freaky fast delivery, has run into some problems because of drivers driving very, very rapidly trying to get from place to place. Sometimes employers can be held responsible because they are negligently supervising their employees or because they are negligently training their employees. That's a separate thing, and that's not what we're talking about when we're talking about vicarious liability. So keep that in mind. The vicariousness, by its nature, means that the person who is being held responsible hasn't done anything wrong. And so again, employer-employees, the typical circumstance. There could be others, but that's pretty much the typical one. Assumption of the risk. The book discusses contractually assuming risk by signing an agreement to assume the risk. That sort of takes it out of the realm of tort law, really, and puts it into the realm of contract. One of the areas where you'll see this are people signing waivers when they engage in certain activities. The question is whether those waivers are valid. This particularly arises when you have kids going to summer camp, for instance, and mom and dad are asked to sign a waiver. And I've had parents ask me for many years now, I'm sending my kid to camp, they want me to sign the waiver, should I sign the waiver? Well, of course, the camp says if you don't sign the waiver, the kid can't do anything. So I always tell people, sure, go ahead and sign it. It doesn't matter anyway because you can't waive your children's rights. You don't have that authority. The law won't let you. And I know that was true in Virginia, and I don't know if it's true in other states, but it most likely is. So normally, most of the time, you can't waive somebody else's rights. That even includes your children. The law doesn't let you waive their rights. So contractually assuming the risk usually means that the person who's signing off on the assumption of the risk does so knowingly and has capacity to do so, right? And that would be a contractual matter. Tort assumption of the risk has to do with understanding what's going on. Now, this arises again from me as a guy who did years worth of insurance defense work and was constantly involved in car accident cases. This came up in drunken driving cases. Did the plaintiff who got in the car with the person who was intoxicated assume the risk of the intoxicated driver's drinking and driving? And of course, the answer could be yes or no, depending on the circumstances. But the basic idea there is, did the injured party, did they know the person who was driving was drinking? Were they aware of the drinking? Were they aware of the effects of alcohol on a person? And did they nonetheless get in the car knowing that the driver had been drinking to excess, perhaps? And how much, and you would get into some factual issues about how much did the person drink, was the injured party aware of how much they had to drink, and those kinds of things. But the basic reality was, if they knew enough to know better than to get in the car with this person, then they may have very well assumed the risk. And so that would be a classic example of assumption of the risk. Last clear chance, here's what I'm going to say about it. Last clear chance is really on the outs as a meaningful tort doctrine, at least from a practical standpoint. And so I'm not really going to talk about it much, just to say that a number of jurisdictions just don't seem to give much to the idea of last clear chance. It's out there, it still exists as a tort doctrine, but it doesn't seem to have the kind of oomph, so to speak, that it's had in the past. The basic idea with last clear chance is that a negligent party had the last opportunity to avoid the accident, and because they did, they are held responsible. Contributory, so I'm not going to talk any more about that. You'll read briefly about that in the book, and you can pick up on that and what it's worth. Contributory negligence and comparative negligence are much more important ideas that you need to think about in tort law. Most states, let me start by saying this, all states recognize contributory negligence. You'll hear about comparative negligence and you'll say, oh, well, that's different. No. Comparative negligence is a vein of contributory negligence. Really what you have is pure contributory negligence and then essentially partial contributory negligence, which we usually refer to as comparative negligence. Virginia, for instance, is a pure contrib state, and there are several others. It is a doctrine that has fallen on hard times. Personally, my experience with contributory negligence was such that I think it's overblown. The problems with it are overblown. I think it's a much simpler methodology for dealing with the negligence of the plaintiff. And so I personally, I think it's probably the best way to handle it, because the comparative negligence standard has created all kinds of other issues and problems that don't necessarily need to be taken into, that need to be dealt with. And let me explain what I mean. In my experience with contributory negligence, which is, by the way, which means that the person who's making the claim is also negligent. In the case of contributory negligence, the defendant, or the party who's being blamed, is negligent. I mean, they have committed some act of negligence. It isn't a question about whether the other guy is negligent. The question is the person who's making the claim also negligent? Plaintiffs' attorneys used to bellyache to me all the time about how unfair it was that just any small amount of negligence in Virginia could result in the plaintiff losing the case. But the fact is that, as a practical matter, in my experience, juries and judges simply didn't operate that way. The way they operated was that if a plaintiff were a little bit negligent, just a tiny bit negligent, then they simply disregarded it and just said, yeah, they may have been a little negligent, but we're not going to let that decide the case for us. Many attorneys, I'm going to give you an example here, would, I don't even know what's written there. Well, that's not for you, whatever it is. They would make this argument and say, hey, if the plaintiff was just this much negligent, and they'd tear off and they'd say, oh, if they're that much negligent, if there's that much contributory negligence, the plaintiff loses. Now, I never did that because I thought it was stupid, and also because I don't think that people think that way. I just think that juries just wouldn't accept that unless the plaintiff were just a really bad actor, and that wasn't typical. So that really isn't how contrib works, at least not in my experience, and I tried a lot of cases. And mostly what I found was that juries balance things out, judges balance things out, and would really think about it carefully before they gave a verdict in favor. Basically, they did a comparative analysis. And so you don't need comparative negligence because people are going to be fair. I mean, and so they will treat people fairly. Comparative negligence is based on the idea of, well, let's be fair. We want to be fair to people. But pure comparative negligence, if you think about it, really isn't necessarily fair, at least not in my estimation, uh, because I'm in Kentucky now, and in Kentucky you have pure comparative negligence. Well, somebody could be 10% at fault, and you could be 90% at fault, and you can still sue the guy who's 10% at fault to get your 10% out of it. There's something wrong in my thought about a system that allows that kind of uh, uh, use of the courts. It's a waste of time, it's a waste of energy, it's a waste of money. If the person who is only 10% to blame and doesn't sue, and then the person who's 90% to blame sues, there's just something backwards about that to me. Again, that's just a personal opinion. But that would be pure comparative negligence, where technically uh, the party who has a significant negligence can nonetheless make a claim. My suspicion, and I haven't observed this in Kentucky because I'm not actually actively practicing in Kentucky. I work at a law firm, but I'm not actually actively practicing. But my suspicion is the way that works itself out is similar to the way it worked out in Virginia with pure contrib. That is, juries think it through and they try to do the fair thing and probably punish people who sue despite being mostly negligent, and probably ultimately don't give them anything. That would be my guess. I don't know how it works itself out in practice. If you're going to have comparative negligence, it seems to me that what the book refers to as impure, what I would refer to as modified comparative negligence, is probably the more reasonable way to go, and that would be that there's some standard that's set that if the defendant has to be a certain amount negligent before you can prevail against them. And so, for instance, a defendant would have to be arbitrarily, say, 51% negligent, and if they are, then the plaintiff can't prevail against them. Again, really all that's doing is saying both parties are negligent, and notice that in contrib and in comparative, whether it's pure comparative, whether it's the modified or impure comparative, both parties are negligent. And we're just trying to figure out how do we balance out the competing negligences, if that's a word, of the parties. And so that's really all we're doing. You're welcome to your own views, and I will, in fact, hopefully hear about some of those views based on the hypothetical that you'll be working on in this unit. So one of the questions is I'll tell you now, one of the questions is asking you to talk about which one you think works the best and why. So I want to see what you have to say and hear your opinions about it. I'll be very interested to read those.